Hello, I'm Justin M. Kennedy, an attorney with Litherland Kennedy & Associates, a California estate planning and elder care law firm. Today I am going to discuss wills. We see wills in movies and TV shows all the time. People are always talking about creating or updating their wills. But what does a will do? Broadly speaking, wills do four things. 1. Upon your death, your will lists who you want to serve as the legal guardian for any minor children that you have. The minor children would then live in that legal guardian's home, and the legal guardian would be the person to sign the children's parental permission slips and take them to their doctor's appointments. The probate court would review your selection for legal guardians to make sure that the person you have selected is going to provide the minor children with a safe household. 2. Your will lists who will act on behalf of your probate estate. This role is often called the executor of the estate. This is an important decision as the executor is who is in charge of paying your final expenses and distributing to your beneficiaries. Your executor is also allowed to be compensated under the probate code using a percentage of the value of the probate estate. 3. Your will revokes any prior wills that you have ever created. You might be thinking that you have never created a will before, but that may not be the case. Imagine back in college that you had a sweetheart, and for your anniversary you wrote that sweetheart a cute love letter saying that all your stuff should go to them. Fast forward to today, you might not have seen that college sweetheart in over 20 years. Yet upon your death, that college sweetheart could show up with that love letter and challenge your spouse, challenge your children by saying that all of your assets should go to that sweetheart and not to your family. And unfortunately, that love letter may be a valid will under California law. That is why it is good to revoke any prior wills. And 4, your will lists where the assets should go upon your death. For a last will and testament, your beneficiaries may be individuals, your spouse, your children, maybe your friends, or you may leave your assets to charities. Another type of will is a pour-over will. This is typically created along with a living trust, and the beneficiary of a pour-over will is your living trust. Upon death, if we need to use your will, it means that we are going through the expensive and time-consuming death probate process. For most situations, a will should be treated as a safety net, where we hope that we do not need to use it, but the will is just there in case we need it. For those creating a will, please note that a standard will needs to be witnessed by 2 independent witnesses. When a client signs in our office, we provide the 2 independent witnesses. If you found this video to be helpful, please hit like and subscribe for future content.